Welcome to The Buy-In. My name is Trent Cripps, Director of Property Strategy at Sevenfold Property Group, and I'm also a long-time avid property investor myself. My co-host, Simon Podger, is Director of Lending for our sister company, Your Future Strategy. Please note, all the opinions and information in this podcast are of general nature only and should not be relied upon as advice. You should always seek professional guidance at all times before making any investment decisions. Please see the link at the bottom of each episode. Okay, next guest for our podcast is Lisa Croy from Croy Legal. We're going to be talking all things conveyancing today. Welcome, Lisa.
Yeah, welcome, Lisa.
Thank you for having me.
Yeah, so I suppose from my point of view, usually the lending's already and the property is already purchased, etc. We're sort of like a couple of steps back sort of thing. So if you've got a client out there who's looking to buy a property, what's their steps in terms of the legal sort of side of things and the conveyancing side of things?
I think it's very important for people to understand that involving a conveyancer and or solicitor is important early on, because where we often get involved is contracts already signed, it's fully executed, binding contract, terms negotiated. We would love to see us getting involved earlier. So either when a buyer's looking to buy, contacting us, say, look, we put an offer in. At that point in time, we contact the agent and get the agent to send the contract to us before it's executed. Yeah. With a seller, even more important, because the purchaser can often put clauses in there where they've got options to be able to exit the contract throughout the process, whereas often with a seller, the seller, once they sign, as long as the purchaser meets all the conditions, they can't exit that contract. So from both a seller and a buyer's point of view, I do believe getting a solicitor review the contract before it's signed is important. Yeah,
and I suppose it's really similar to what Bodie, our tax extraordinaire, was talking about, is that it's sort of too late once you've settled on an entity that you're going to buy and all contracts are signed. It's too late then to go back and change things. So it's really important to do that. And I suppose my question was, what's your experience with clients when they say that to real estate agents? Is it a big deal, or are the agents usually like, yeah, that's fine, no probs, I'll send it in? Or is it a bit of a mixed bag? Or
without being critical of real estate agents, we do see a lot of buyers and or sellers being forced in a quick, let's get this done, we're going to lose the buyer, or just that whole aggressive sales tactic. It won't be a problem. The amount of times I hear, don't worry about it, we can fix that later, worry about that later, and then we get the contract and we've got to deal with the mess. And there are times where if the other party doesn't agree to making a change to the contract, it can have really serious consequences. Yeah. I would like to say that that's rare, that we don't deal with that very often. Yeah. Unfortunately, for the contracts where we get it, it's already fully executed and all done and dusted. I'm alarmed at the amount of times where there are issues in that contract which cause pretty significant issues throughout the way. Most of the time we're able to resolve it, but we'd rather not get into the situation where you're having these issues. It'd be much smoother if it was sorted out, terms and conditions reviewed by a solicitor. It would be a lot easier. Yeah,
so I suppose like if I'm starting out looking for a house sort of thing, maybe a quick email to your solicitor or conveyancer saying, hey, I'm looking, is it okay if I send you the contract sort of thing? I'm generally okay with most of them will just say, yep, that's fine sort of thing. And a quick overview would solve a lot of issues.
I think if you've got a good solicitor or conveyancer, you tell them you're buying, they understand that that should be within a 24-hour process, that's a time-sensitive thing. If you've got a solicitor that's experienced in that state contract, they should have seen 1,000 of them. Yeah. That review should be a relatively quick thing that they can actually take a look at, say it's standard, there's no issues with conditions, and anything that you need is dealt with in those conditions. So
and that was my next question, is we're even talking about even those standard real estate institute contracts, they still should be reviewed as well, just to make sure.
Absolutely. Yeah.
Just touching on that, Lisa, what is the difference between a solicitor and a conveyancer?
A solicitor is a qualified lawyer, and a conveyancer is qualified in conveyancing but doesn't have a legal degree, so is not actually able to provide legal advice. So during a transaction, and I want to say this up front, it's probably something that we can deal with later on, but every single state in Australia has different laws, different conveyancing laws. A conveyancing transaction is very different in each state. So when we're talking conveyancer versus solicitor, it is actually different in each state as well as to what each one can do. But I guess to pinpoint it, it is if you come across, while a conveyancer is qualified to do a conveyancing transaction, if you come across a legal issue, that requires legal advice. So contract review would require a lawyer because they're giving you legal advice. Throughout the transaction there may be an issue that requires you to get legal advice. That would be required to step it up from a conveyancer to a lawyer. If you've got a problem at the back end of the transaction as well, you may need to engage a lawyer as well. So it's the ability to be able to provide you with legal advice that differentiates a conveyancer from a solicitor.
And that was my next question: is if things do go pear-shaped towards the end of the contract, sort of thing, they can't sort of advise you, as what you're saying. You've got to then go and seek elsewhere. Hopefully, they obviously know someone or something like that to assist. And
it's a very interesting thing when you're out there looking for quotes for a conveyancer or a solicitor. A conveyancer can certainly handle the transaction, but you're going to get that at a discounted rate. That's great. They can do the transaction from start to finish. It's where something you end up with a hiccup or a problem that they're not actually able to handle that transaction and need to step that up to a solicitor. Whereas if you've engaged a solicitor at the beginning, they've given you a quote for the conveyance, it's going to include, unless something really goes out of scope, they can cope with giving you legal advice throughout that process.
More as a probably a bit of a heads up or a warning for some people, what are some of the things that can go wrong? And I know the list is probably endless, but
I was about to say.
Yeah, just give me a few that spring to mind just for our entertainment. No names attached.
There are, Trent. I don't know where.
How long's a piece of
string? I don't know where to start.
Okay.
There are so many. Simple example would be something along the lines of where the contract is drafted, that the deposit is paid on the day that the contract is signed. So the buyer signs, and then the real estate agent goes off to get the seller to sign. That afternoon, purchaser is waiting. The agent gets there at 3:00 that afternoon, gets the seller to sign, and then he goes back to his office, and their contract review team is gone for the afternoon, so the contract doesn't get circulated until the next day, doesn't end up on your solicitor's desk until the next day, and the purchaser, their bank limit, it was a $50,000 deposit, but their bank limit was $20,000. So they haven't paid the deposit within the time under the contract. They're in breach of contract.
Wow. Straight
up front. Yeah. Straight off the bat. The issue that you can have is most of the time they would pay the deposit the next day, receipts would be issued, and no one would take issue with it. But we have had circumstances where the seller has got seller's remorse or had an issue with that, and that breach has been called upon as a reason to terminate the contract. And if they do that, for example, so let's say they've paid their $20,000 today, paid $30,000 tomorrow, so they've paid their $50,000 deposit, the seller can terminate the contract and retain the $50,000 deposit because they've been in breach of contract. So and then you've got a fight, and it's a big fight to have. So
and they're not telling you that you're in breach of contract or anything like that. They can sit on that, for weeks and stuff like that, as
we have had issues where the seller has, even though it's been remedied, called it out later on at a later stage and said, you were in breach back at this point in time, you breached the contract, I've got a right to terminate the contract as a result, and then retain the deposit as a result of the breach.
And I'd say that happens all the time because people go to auctions on weekends and stuff like that, and then there's obviously bank limits for transfers, for big transfers, and the bank's closed and all that sort of stuff. So as you said, it is the Monday okay, I've got the majority of it out, but then, okay, I can't do it, and then Tuesday I'll do the rest of it, sort of thing. So you can see how this happens really easily.
Oh, and it's all that sales, heavy sell. Let's just sign it. And the buyer sees that it's a $50,000 deposit. They go, yeah, that's not a problem, but it's those little things. Is, can I pay that deposit, physically get that deposit into that trust account where I'm required to do within the time frame that's in the contract. So we always recommend 2 to 3 business days for the payment of that deposit. There is a clause in there that states that I will go back to Queensland REIQ standard terms and conditions that say that if you have paid the deposit and you send the receipt to circulate it to the seller and they know that it's been paid, you get an extra 2 days. The problem is a lot of people don't know that, and if your solicitor hasn't got it and they're not pointing this out to you and you don't send that receipt to them, you don't get those 2 days. So it is important to, when you're doing your contract review, it's one of the first things that I point out to them is you need to pay this deposit by this time. Do you have that bank limit? Can you do that? Because
so I suppose coming back to it like this, it's seek the advice early, and when you're getting from the pressure from the agent and stuff like that, just stick to your guns and just say, no, I'm just going to get this done. I'm really happy with the house and the terms and everything like that. I just got to get it over to my solicitor to have a look at. It's a simple conversation, which sounds like
it's... And you can, certainly in Queensland, other states it can be a little bit more difficult, but I say, look, if you're getting that heavy pressure sell, get a special condition in there that the contract is subject to your solicitor reviewing the contract and being satisfied with it within 2 business days. Then you've got that, at least somebody reviewing it, and you've got a condition in there that may allow you to make an adjustment or deal with it.
Which your solicitor could provide to you well before, when you're shopping. Just say, yeah, that's fine, just insert this into it, and once it's signed, not ideal, but at least you've got something come back there, sort of thing. So.
Exactly. The other thing we see often is when they're pressured into getting the contract signed in a certain name or a certain entity where they didn't intend that's the entity that they do want to purchase in, or they've spoken to their accountant. That's a rescind the contract in certain states, which is costly, and the seller might not agree to that. So I will say, if the entity hasn't been established or you're not sure about the entity that you want to buy in, that there's in some states you are very restricted on an N or nominee, and there's double stamp duty implications there. Spelling on the contract as well. People using nicknames or not putting the correct spelling on the contract causes us big issues.
Missing middle names.
Missing middle names, or special conditions that are drafted or pulled out of a real estate precedent bank of special conditions that can have big issues for us because, for example, they've got 3 dates in the one clause, so the entire clause can't be satisfied. For example,
conflicting is what we mean.
Subject. I'll give you a perfect example. Subject to the sale, a buyer is making this contract subject to the sale of their property, and the clause has been drafted that it's subject to the contract being entered into, the contract going unconditional, and the settlement of that contract, all in one clause. And so you have no ability to be able to satisfy part of that clause. Has caused, we've had some a significant barney in just around that particular issue itself.
From a non-lawyer, you can sort of see what the intention is, but from a legal standpoint, you can see that that's not going to work.
You have a solicitor on the other side that takes issue with it, and all of a sudden you're in an expensive argument.
And that was one of my things is we see it quite a lot when people do that. They're selling the house and they're buying another one, sort of thing. And I'm always like, people are like, oh, that's okay, it's unconditional, the sale contract. And I'm like, but that doesn't mean that it's going to happen. They could still default on that contract, and then you could be left in a problem to try and fulfill your next contract as well, sort of thing.
One big thing we are seeing at the moment is we've sort of gotten out of that bull market, and we're seeing a lot of subject to sale contracts being entered into. Once upon a time, I would say 3 years ago, they just didn't exist. If you weren't cash ready to go, organised, got yourself together, or just the sellers were just saying, you've got to take that risk, we're not going to do it subject to sale. We're seeing a lot more subject to sale contracts coming through now. The one big issue that we are seeing with the subject to sale is, from a seller's perspective, $5,000 initial deposit. The deposit is paid 50 the $50,000, the balance deposit, is paid upon the contract going unconditional. It's building and pest and finance. But because it's subject to the seller's sale, that contract is never going unconditional.
Yeah.
So we're seeing sellers with $1,000 deposit on the contract is going to be conditional until the day it settles. Yeah. We're seeing this so often where the seller has got no recourse to get a deposit. Which is a big issue for a seller if, for example, the buyer for some reason can't affect the sale because because it was subject to another settlement. Yeah. The seller's only recourse is $1,000, for example. That deposit's not paid.
And it's a reasonable amount of time to be off the market effectively without much security. And unfortunately, a typical real estate agent would leave that listing up on the market, which gives the perception that the property's gone stale. And other buyers might not come into the market so quickly on it. So
the amount of times I'm doing a contract review at the moment that I'm saying to a seller, you do realise that if you sign this contract, the balance deposit will never be paid. So I suggest you change that to being the balance deposit is paid upon satisfaction of the building and pest or upon satisfaction of the finance, because there is that still the condition that's subject to the sale, which means the contract in effect is never going to become unconditional.
Lisa, one of the things I quite often with the investors, you've got a husband and wife situation where the accountant is giving them advice around perhaps one of them structuring at 80% in their name and 20% in the other person's name for tax benefit. Who do they communicate that to, and when is the right time to communicate that? Is that pre-signing or once the contract's signed?
No, that's a part of the conveyance. So that's what's registered on title the day it settles. So that's loaded into your Queensland titles, for example. That's what we load on the transfer documents and what's recorded on title. That, unfortunately, because it's front of mind when you're doing the purchase, talking about it, unfortunately what happens is a lot of people, and you get excited, the contract signed, the conveyance starts, and they get through that process, and that what we find a lot is that's forgotten to be communicated during that conveyance process, and therefore which the conveyancer should be checking that, and that should be a question that's being asked. But I think what happens is a lot of time there's a lot of documents to fill out, a lot of tick boxes to complete, it gets missed. And so that joint tenants in common question, a lot of people skip past it because they don't understand it, or a lot of people miss it during the excitement overload of that conveyance process.
And I suppose just good segue just to taking a step back. Can you explain the difference between tenants in common and joint tenants?
Yeah, so joint tenants is a joint 50-50 ownership, and if should one of the parties pass away upon their death, it is automatic that their share in that property will automatic pass to the other party. And it's a relatively simple process of registering a record of death to just transfer the property into the other party's name, which for husband and wives, at the event of a death of one or the other, I'm going to tell you that at that point in time, it is a great thing to be able to not have the property not be dealt with in the estate, and leave the other party to just have the property just is transferred straight into their name. With tenants in common, it can be for example, a non-husband and wife where you want to separate that ownership. If one party was to die, that their share of that property automatically transferred through to their estate and is dealt with in their estate.
So a couple of like business partners, say, or something like buying something together.
Yeah, or a de facto couple that aren't fully committed to each other.
Two brothers or something like that.
That's exactly right. The other advantage is if you're doing joint tenants, you can alter the percentage. So with joint tenants, it is 50-50. That is locked. Where if you are doing tenants in common, you're actually able to adjust from that 50-50. So from a tax perspective, someone's got a higher income, they could increase their share in the property and get higher tax benefits from that. So there may be a situation where a married couple may choose to do tenants in common for tax advantages.
Yeah.
Not that I'm giving tax advice here, but that is a reason why they may choose to do so. But yes, if the parties are not a husband and wife, or that sort of a relationship of parent and child wanting to automatically gift that share to that child, you would certainly consider tenants in common so that share of your property passes to the estate rather than automatically to the other person.
Yeah, and it's similar to the tax sort of thing, is that there's advantages during ownership to have it certain splits and stuff like this from Bodhi sort of thing. But then once you sell the property, it could be the actual inverse way, depending on where they stand sort of thing. And then it sounds like that could actually be a negative or positive depending on your estates and all that sort of stuff and wishes sort of thing. So it's almost like you can never get that perfect parallel line, I suppose, what I'm trying to say. It's all, you've got to consider your own sort of what you're trying to outcome with the property and stuff like that, and what you're trying to do.
I do believe it's very specific to the type of property, and it's very specific. So whether it's your owner occupied, who you own the property with, what your intentions with the property. Yeah, so it's not only individual people's their entire situation or circumstances. It's also, I guess, property based as well. So you might choose to do your joint tenants with your owner occupier, but do tenants in common with your investment property. So it's a very specific transactional consideration, but considering your overall portfolio as well.
Yeah, so not just the cut and paste, that's what I'm doing, for all of them sort of thing. You got to consider it for all and look at all the facets, So.
The amount of people that I speak to where I'm talking to them from an estate planning point of view or from a family law point of view, and I say to them, do you hold the property joint tenants or tenants in common, and they can't tell me, is alarming. And it just means it I guess raises that issue with me, that a lot of people do not understand the importance of that very thing, because that should be something you should know always. If you own a property, how do you hold your share in that property? It should just be, if someone asks you, you should be able to say, I own that tenants in common, or I own that joint tenants. I just find that more often than not, when that question is asked, people do not know.
Yeah. And can I ask, left field, is there any sort of little legal jingle or anything like that to remember which one's which? Because I'm sure it always gets mixed up and people forget which one's which. And
yeah, I mean, over the years, I always find the joint is joint, so it's jointly owned. Yeah. Therefore, it's
together.
Yeah, you are together. Yeah. The tenants in common is the one that's separate. Yeah.
Maybe common shares or something like that.
Yeah, I would say probably that. Remember, the joint is the one that means that it is joint. It is co-owned.
Lisa, we've found the right property. We've put a contract in front of you before signing, ideally, and gotten the advice from you. We sign. The contract goes over to Simon and his team to try and get the finance for the property purchase. What's the next steps with you in the conveyancing / solicitor space? When we talk things like searches, I know we could talk quite lengthy about that, but what are some of the standard searches that would typically be done on a contract?
Title search, obviously, council search, body corporate search. If it's a body corporate, we do a plan search, so they're your standard searches that are done. A land tax clearance is required. Certainly, from what I understand, most states' land tax clearance is required. I will say plan search is one of those searches where a lot of people don't really realise the importance of it, and they stick it under their nose and they sign it off. Alarmingly, people do settle on the wrong property, and they have had a plan search put in front of them. Yeah. The conveyancers sitting in their office, wherever they are, they've never laid eyes on the property. When they do the plan search, they don't know, they've never been out there and inspected it, which is why they give you the plan search and ask you to review that and look at it and make sure that is the property that you are buying.
As a fail-safe.
The amount of people that sign off on that plan search, and as I said, I've dealt with it more often than we should, where that plan search has proven to, I guess, should have protected the buyer should have picked it up at that point and said, that's not what I'm buying, but don't know. They just kind of sign here on the dotted line with lots of paperwork. So
sounds like an expensive mistake.
and there are, look, again, often people come to us as solicitors and say, what searches should I do on this property? There are hundreds of searches available. We're not out there at the coalface in front of the property, so you really need to be involving your solicitor on talking to them about what area is it in. Could there be contamination? Could there be a fire risk? Should you be doing main road searches? There is literally hundreds of searches that you can do. There are free searches, but there are other searches that can be quite costly. We do get panicking buyers that want to do every search known. In a unit doing a spotted frog search in a complex that has a little backyard, and we try and convince them that that's probably over the top. But you really need to be advising your solicitor on probably all of the little things, that intricacies about that particular property, to try and understand what searches are available to you, but are they necessary?
And I was just going to ask, just in terms of the timing of searches as well. So, we've obviously, everyone knows the main ones where we were trying to get the finance done and the building and pests and things of that nature sort of thing. Are they done at that sort of stage, after those sort of thing, or or maybe during the whole process?
We have some really significant changes coming out in Queensland, because other states, the seller's disclosure has been a big thing, where the seller's required to provide you with a lot of the searches that you need to look at as a buyer to understand, to get a full understanding of the property that you're buying, the searches, the sewerage, the environmental issue, all those sorts of things that other states have for years. That information is provided at contract stage. In Queensland, it's been really a buyer requirement, so you sign the contract and the buyer has to go off and get those searches. That's changing come 1st of August. So we will be in line with other states where we'll be required to provide the seller will provide a lot of those important searches that are required.
And is it a set list that you have to provide?
Yeah, there are prescribed. There is a prescribed disclosure statement with prescribed a disclosure that you have to provide. So in Queensland, we've been a little bit backwards, and I'm now talking probably. We've got 4 or 5 weeks to go before this legislation comes in and it changes. So often in Queensland, what's been happening is that they'll do a building and pest and do those sort of searches. They might check body corporate records, might make a phone call to council, but in Queensland, traditionally, searches don't get started or they don't undertake searches until the contract's unconditional. And often, if there are issues that are picked up there might not be an ability for the buyer to be able to terminate based on those what they may or may not detect in those searches. So.
That was my next question. Is okay. So we've gone unconditional. We've done the searches and we've found something we don't like. What now, sort of thing?
It really depends on what you found and what the terms of the contract are. But I will tell you that there are definitely things that a buyer will discover as a part of their searches that they've done unconditional, where they don't have an ability to terminate the contract as a result, because that should have been something that they should have picked up probably prior, or had a clause in the contract that allowed them to exit the contract as a result of that. If you're simply relying on the REIQ standard seller's warranties, there's certain seller's warranties where the buyer, if they discover something prior to settlement, that they could terminate, but not all the time.
I'm thinking like we had one years back sort of thing, if you remember, and it was near an old army base, and I think the buyer actually put a specific clause in there saying they wanted to do like a disposal search. I can't remember what the exact term was, to see if there was any unexploded ordnance left there or something like that it was actually okay, sort of thing. So it was lucky they did. It was okay, but
and that's why it's important to, I guess, to fully explain to whoever's handling your conveyance that transaction for you what could be some of the unique things about the property that you're buying, because there's hundreds of searches, so if there is something unique about it, you may want to do an additional search. Land resumption, for example, those sorts of things. The seller has a warranty if the resumption notice has been issued, or there is a building show cause notice, they're required to disclose those. But if those notices haven't been issued, then they may not have recourse. The buyer might not be able to exit the contract.
So once we get past searches and we work our way towards settlement, what is involved with settlement, i.e. on the day of?
Probably, I'm going to take that back a bit, and I'm going to go, what's week of? You should be preparing a week out.
True.
What the buyer and seller solicitors will do is they will exchange searches that have been undertaken, council searches, body corporate searches, land tax searches. Those are exchanged between the seller's solicitors, and then they will do a settlement statement. That settlement statement's then exchanged and agreed on. And so then we've got a figure that we're all working towards. That should be approved by the seller and certainly the purchaser, but at that point in time, that should be done sort of 10 days to a week out, so that then you're advising the purchaser how much they need to prepare to be contributing towards the purchase as well. So those sort of conversations and discussions need to be had, so that if there's a bank involved, really importantly, who's holding the purchaser's equity? Is it being held with the solicitor's trust account? Is the bank going to hold it? A lot of purchasers don't understand that they tick a box in their loan documents that states who is going to be doing that. And often if that's misunderstood, it can cause a delay with the settlement. So getting that, understanding where the purchaser should be putting their equity. If you have a choice and you have a bank involved, I would always be saying path of least resistance is to put it into a bank account that the bank's got, because they can turn up with 100% of the funds and there's no fiddling around, solicitor's trust account, etc. Coming up to settlement day.
Sorry, can I just jumping on that on the lending side of things? If you're new to that bank, make sure that you have set up like just an everyday bank account before that, get ahead of the game sort of thing, so you've got somewhere to park the money, because the banks won't take a deposit or debit another bank's account at day of settlement because it's not cleared funds.
That's right, so it has to be in a bank, an account with the bank that you're lending with, and that needs to be done rightly well in advance of your settlement day.
You just see it happen all the time because obviously with bank packages, I'm getting the credit card, I'm getting the bank account and all that sort of stuff, like the annual fee, and it's like, yes, that will happen, but they send out the letters and the banks, the PIN codes and all that sort of stuff. But you've got to get ahead of the game on that sort of front sort of thing.
Make sure you have the bank accounts open, you have access to it. So getting that from a purchaser side of things, understanding that. From a seller's point of view, some really critical mistakes that are made is in Queensland, ATO clearance certificates are required on every sale in Queensland now. If you do not provide a ATO clearance certificate that is in the name of that matches the name that's on title, if you don't provide that, they can withhold 15% of the purchase price and it has to be remitted to the ATO. Now, what a lot of people don't realise is the ATO have a mandatory 28-day period for them to provide that certificate. So if you've signed a 30-day contract and then you wait a week to get on and order your ATO clearance certificate, and there is an issue with that certificate, the ATO will not touch that for 28 days. So you then have 15% of your sale price, and that's not a good conversation to have with the seller, that we're about to retain 15% of your sale price and we're going to remit that to the ATO, and you can have that discussion with the ATO at settlement. So,
and especially if you're doing something else, like
that you need the funds.
You need those funds for the next purchase or something like that that's lined up. Or
it is a white knuckle ride for us where we don't get sellers to engage with us on those ATO clearance certificates, or if there's something gone wrong with the ATO records that don't match the title. That is, I'm telling you, it is as I said, a white knuckle ride. The other thing that we find is sellers can be very not so diligent on getting their lenders' discharge documents completed. The lenders will not, it doesn't matter what we do, they will not deal with the solicitor acting. You can tell them you're acting, we can send through at the authority that we can act, but the lenders will not deal, they will only deal with the borrower needs to engage with them, the borrower needs to complete the discharge documents and send it through. So trying to explain that to your client, we can't assist you with that, you need to get on involved. Once you've signed the discharge, we can deal with the bank, they will do it, but they won't do it until you sign that form, and often the form needs to be a wet signature, they've all got their own individual requirements. So leading up to settlement, I would say, seller, you've got to be onto your ATO clearance certificate, you've got to be onto your discharge documents, dealing with your conveyancer on making sure that you're following those steps that they need. From a purchase point of view, you need to make sure you understand where your purchaser's equity is going to be paid, how that process is going. There'll be requirements to lodge with the stamp duties office, so you'll need to make sure those funds are clear for settlement. So that's all leading up to the settlement figures are probably should be agreed to sort of a week out, but some days we're still doing it the day of settlement because of issues with the other side that aren't organised. But coming up to settlement day, we're all agreed. In Queensland, we're mandated to do an electronic settlement. Most conveyancers that I know or solicitors that I know are using an electronic network system called PEXA. So a PEXA workspace is established. That's done usually at the file opening stage, where the PEXA workspace gets opened. People get invited to the PEXA workspace. So the buyer's solicitor, the seller's solicitor, the buyer's bank, the seller's bank, exiting bank are all invited into this workspace, and we start communicating with each other through the workspace. Important documents are uploaded through the workspace. Stamp duty is lodged in this workspace. So then leading up to settlement and on settlement day, we're very much in this workspace, balancing the workspace, making sure that everybody's ready, that funds match, that any disbursements are loaded into the space that need to be purchases, surplus funds, any disbursements from the seller's point of view that need to be paid, so the bank, the payout figures, the titles office, registration fees, etc. The workspace is prepared, everyone signs off on it, the workspace gets locked, and then it then takes about 20 to 30 minutes for that workspace to settle. Usually there's automated emails that will go out afterwards. With these workspaces, we will book a settlement time. Any time from sort of, generally 11 through till 2:30 are the most common times that are booked. But those workspaces, even though it may have been booked to settle at 1 o'clock, everybody might not be ready and signed off. What buyers don't understand or sellers don't understand is they'll roll over every half an hour and can legally continue to do so until 4 o'clock. So when you've got a buyer who's packed up all of their belongings into a removalist truck and is sitting outside the house waiting for the keys, and those settlements continue to roll over, and that it is problematic if you don't understand that you may have a 2:30 booking for settlement, but it may not happen at 2:30, it might not happen till later. The other thing too is in some states, for example, let me say Queensland, there is a clause where it automatically allows either party to extend settlement by up to 5 business days. A lot of people don't realise that that's the case. They have their planning, they've got their removalist truck there, and at 2 o'clock the email comes through saying we've just extended the settlement by 5 days, which is a week, 5 business days, which is a week, and they've got nowhere to go. Or the seller's got another commitment where they needed those funds and they automatically extend. So it's really important to understand, is settlement day locked, and is there any ability for that to be extended?
There's a lot of considerations. Lisa, thank you so much for your time. Principal of Croy Legal, a very exceptionally busy woman. We really do appreciate your time. And it's been great. I'm sure there's a lot there for people to digest, and we'll certainly have you back and be covering off some other topics. So thanks again.
Yeah, thanks again, Lisa.
No worries. Thanks for having me.
Please note, all the opinions and information in this podcast are of general nature only and should not be relied upon as advice. You should always seek professional guidance at all times before making any investment decisions. Please see the link at the bottom of each episode.